Welcome to Sakshi TV Special Immigration Show with attorney Chan Parvathaneni from Sim Parvathaneni and Braun. Please note that Sakshi TV now has three immigration shows every week. At 5:30 p.m. EST on Thursday with Chan Parvathaneni, at 3 p.m. EST with attorney Prashanti Reddy, and on 5:30 p.m. EST on Fridays with attorney Banu Anindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 876-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need any specific legal advice, you can contact the attorney directly. The firm that Mr. Chan Parvathaneni works for is a great firm with provides with ample amount of information from anyone related to immigration to different laws available on the internet. We should also note that Mr. Chan Parvathaneni comes to our show every day on Thursdays. Before we begin the show, please also note that this show is, you can call us on the numbers on the screen. And before, also, Mr. Chan Garu, welcome to our show. How are you?
Thank you, Shwani, and thank you all Sakshi viewers.
Yes. Mr. Changaru, today we will talk a little about the various immigration laws. So, and also about the recent H1B updates. So, are there any updates that we have to discuss this week?
Sure. So, I mean, everything so far this year, at least on the US side, things appear to be smooth and normal, not any major changes in laws. The approval rate seems to be very good. And in terms of the main updates, currently the lottery that has happened in March, the H1Bs, the cap filings have started. So whoever has got selected in the lottery, so those filings have started. And the deadline is June 30th. So a lot of people have been applying. So we have applied numerous cases. We've been seeing approvals. And things seem to be smooth. We're not really seeing any weird or bad RFEs. And the approval rate and the approval percentage seems to be in line to what has happened last year. Last year, the approval rate was very high compared to a couple of what we used to see a couple of years back. And we do anticipate to see a smooth H1B cap season. So anybody who's applying for H1B for the very first time, anybody who has just gone through the lottery, more than likely they should probably see an approval, assuming the job is a bona fide job and they're qualified for the job. And that being
Yes.
said, another update on the green card side is that USCIS, they have been moving a lot of cases from other service centers, namely the Texas Service Center and Nebraska Service Center. They've been moving a lot of pending 485s, employment-based 485s to National Benefit Center. And it appears that things are getting speeded up a little bit. And more than likely, we are hearing news that we might see a spillover even this year from family-based to employment-based. We just have to wait and watch to see what kind of numbers will spill over. But overall, things are looking like they're getting streamlined, and hopefully, the people who are waiting in the queue for the green cards and who have already applied for their 485s can hope to see their cases streamlined and processed a little bit more faster in the next couple of months.
Yes. So, Mr. Chan, I was hoping we can get on with our topic today. So, the first question that I have for you is that how does one apply for a visa with the consulates through the DS 160 form, and how much exactly is the typical cost for applying it?
Sure. So, in general, any non-immigrant is a person who's not typically a citizen of US or a resident of US. So, anybody outside US who are trying to come to US, they typically have to apply at the consulate, and they apply at the consulate, the US consulates, the US embassies, using a form called DS 160. So typically, DS 160 is something what anybody would typically need to use. Somebody who's trying to come on a student visa, somebody who's trying to come in as a tourist, or even if somebody is trying to come in as a H1B visa holder. So DS 160 is the form that they have to fill out. And this is an online form that is filled out by the visa applicant. And in general, there is no fee for the DS 160 by itself, but depending on the type of the visa, there is some additional fees. For example, if it's a B1, B2, a tourist visa, or an F1 visa, the typical fee is 160 US dollars. And if it's a H1B, the typical fee is $190. And again, this fee could vary between one country to another country because of various reciprocity arrangements that the US government has with the other country. So, based on that, various agreements that the US has with the other countries, the fees could vary a little bit. But $160 for normal visas, 190 for H1, H1B is typically what somebody would have to pay to get a visa appointment. And uh, the data that is filled on this form, the DS-160, this is what is used by the consular officers to grant a visa. So, in general, things like employment history, addresses, and various things are asked. And it is crucial piece of information that is used by the officers to grant a visa.
Yes. Another question a lot of people have is that can a third party file for the DS 160 form, or one who is applying themselves, they must selfly do it?
So, a third party can also assist in filing the visa application, which is basically the DS-160 form. So, if the visa applicant is, for some reason, is unable to complete the form or requires assistance or requires some translation assistance, and they have a need for a third party to help them and complete the form, that is completely acceptable. The only thing is, one needs to make sure that the third party, whoever is helping the person, the third party has to be identified on the sign and submit page of the DS-160. So, as long as the third party is identified, they should be fine. And the third party should also instruct the visa applicant to endorse the application by asking them to click on the sign application button. So there's a button that says sign application. So the actual applicant should click on that button. And in general, the third party can assist them. And also, if somebody is below 16 or for some reason physically incapable of completing or filling up the application, so if somebody is below 16, obviously the parents of the applicant or the guardian, they might complete the application and they can click the sign application button on the applicant's behalf. And in case somebody does not have a parent, their legal guardian or whoever has the legal custody of the child, they can also, based on the legitimate interest they have with the applicant, they can also submit the DS-160.
Yes. So, Mr. Chan, once the DS 160 visa application is started, is there any time to complete the form?
So once the DS-160, the application, so somebody starts filling out the application. So they have about, typically in 30 days, they can access it and the information is present. And they will have an application ID. So they have to use the application ID to retrieve the previously saved application. So they don't have to do everything in one shot. They can continuously keep updating the form, and they can finish the form in about 30 days once they open up the DS-160. And by that way, they can retrieve the data, they can see and see what they have already input and make any changes and complete the application. The very important thing is every applicant, they should review each and every question. They should make sure the answers are accurate. The DS-160 is executed under penalty of perjury of law. And what that means is somebody is swearing that whatever information is being input, it is true and accurate to the best of their knowledge. And any misleading information that is provided by attesting to the perjury of law could lead to permanent ineligibility from entering into US. So what that means is if somebody gives any inaccurate information, it could even lead to their permanent bar from entering to US. So it is extremely important that there is no willful falsified statements on DS-160. And it is highly important that no mistakes are made as far as any material misrepresentations are concerned. And extreme care should be taken to answer this form because something misleading could cause a problem down the line. And I have seen cases where 10 years, 15 years after somebody has filled in their DS-160, at the time of applying for their green card, during their 485, for example, I've seen cases where USCIS comes back and says, you have given so-and-so as your employer and your 485 or your I-140 or your perm application is showing somebody else as your employer. Clarify. And they issue a notice of intent to deny. So it is extremely important. Take some time and do not even accidentally make any mistake with DS-160, especially with a lot of H1B employees. They go back to India, they fill up DS-160. So take extreme care to make sure all the information is accurate, especially information such as your previous employment, the start date, the end date, what you have done with your previous employers, any kind of information that needs to be put on DS-160. Make sure it is accurate.
Yes. Another popular question is that how long can somebody on the tourist visa stay in USA, Mr. Chan?
So the tourist visas by itself, they are granted in 10-year increments. So whenever somebody goes to the consulate in India, apply for a tourist visa, they get it for 10 years. So the visa itself is for 10 years, but visa is just a document to come into the country. And at the time one is coming into US, the CBP officer, the actual authorized stay, the actual time of authorized stay, that is something what is determined by the CBP officer at the port of entry. And what that means is the CBP officer, they will look at the documents and they will issue an I-94. And this I-94 is a document that every non-immigrant, once they enter into United States, they should go to the CBP website, cbp.gov, and they should download the I-94 document because it is an online document. It is not on the passport. It is online. And extreme care should be taken to see what is the last date on this I-94. If it's a tourist visa, in general, it is a 6-month entry. So normally it is given for 6 months. It does not mean that everybody that enters on tourist visa gets it for 6 months, which is why one has to download the I-94 and then make sure they are looking at their end date. And there is an obligation to leave the country before the end date on the I-94. Usually it is for 6 months, but occasionally if the CBP officer has a reason, they could limit the stay to a lesser time, something less than 6 months. And I've seen cases where somebody got I-94 for a month or for 2 months for various reasons. So in general, it is 6 months, but it could be different for each person. And the only way to figure that out is through the I-94.
Yes. Mr. Chand, I had a doubt. How can somebody with B1 visa extend their stay longer than 6 months? Is there any specific process or any legal thing that one has to go through?
Okay. So once somebody is in the country and normally they're supposed to leave the country before their I-94 expires, and I-94 typically expires within 6 months for a tourist visa. For anybody that enters on B1, B2 tourist visa or a business visa, it typically expires within 6 months.
So, Mr. Chan, we were talking about how one with B1 visa can extend their stay in the US after 6 months. Can you please continue?
Sure. So if somebody has a very good reason and a genuine reason on why they want to stay back in the country after 6 months, there are ways. And the way to do it is by filing a non-frivolous extension application with USCIS. And typically this is done through a form called I-539. This is an application that one can download on USCIS and submit it in paper by mailing it to USCIS, or it can also be filed online. So one can just do an online B1, B2 extension. And they have to pay $370 for the application fee and $85 for the biometrics fee. So by filing this I-539 application, they should be able to extend their status. However, in order to make sure that USCIS does not come back and question them on the reasons, it is always a good idea to upfront let USCIS know the reasons why somebody is looking for an extension. Also show to USCIS that they do have a permanent residence back in their home country. So show some evidence of their permanent residence abroad. Show the reason why you need to file an extension in US. Ensure that this extension application is sent out before the I-94 expires. So as long as a non-frivolous extension application is sent out before the I-94 expires, in general, one should be able to extend their stay in the country even after the I-94 or their 6 month of stay expires.
Yes. Again, Mr. Chand, a lot of people are having this doubt about will there be chances of the cost that increase in the H1B filings? And what are your views on it? Do you think the cost of the filings will increase?
So last year, there were a lot of discussions and a lot of things that happened for people to think that the fees would be increased. But as of today, there is no increase in the H1B filing fee. Currently, the fee is still same as what it was last year. And in terms of what we are looking at for the H1B filing fee, so the USCIS filing fee differs based on the employer, based on the number of people that an employer employees. So what that means is for somebody with less than 25 employees, the fee is 1,710. So that is the fee that one has to pay to USCIS. It's a very expensive process, and USCIS does charge a very exorbitant fee. And currently, if somebody has less than 25 employees, it is 1,710, and this is same what it has been uh, for a long time now. However, if somebody has more than 25 employees, the fee shoots up to 2460. So $2,460 is what somebody would have to pay if they have more than 25 employees. However, if the number of employees in a company it's more than 50, and also more than 50% of those employees are on H1B, so heavily H1B dependent companies, so staffing companies, a lot of IT consulting companies. So these companies, because they have a lot of employees on H1B, they have to pay an additional $4,000 fee. And what that means is they are paying close to 6,460 just to file the H1. And on top of it, if somebody wants to get their case processed in premium, want to get an answer in 15 days, there is an additional $2,500 additional fee. So in general, a company that is heavily dependent on H1B workers, who has a lot of employees on H1B, who have more than 50 employees, they might be looking at as close as $9,000 in fee just to file the H1B, just to file it in premium. So somebody could pay as high as $9,000, and if it's a small company, they're paying as less as 1,710. So there is a big variation based on how people are filing it. Are they doing it in premium or not? And also based on how many people they are currently employing.
Yes. So, Mr. Chan, are there any travel restrictions after applying for the H1B petition? And can H1B or the H1B applicants travel after filing is done in USA? And, what is the process?
So depending on what the status of a person is at the time of filing the H1B petition, based on that, there are some various rules that tell that whether somebody can travel out of the country or cannot travel out of the country. If somebody is already on H1 and they're filing either a transfer petition or filing an amendment petition or filing an extension petition while they are in the country already in H1B status. So for those kind of petitions, if somebody needs to travel, they can travel out of the country. There is no issue. And since their status is already on H1B, those folks will be able to travel out of the country if they need to travel out of the country. Uh, Again, some people decide not to travel out of the country because they want to make sure that they do have an approval and they don't want any surprises. So for most of the people, the practical aspect is that if somebody is on H1 and they did file a H1B petition either for a transfer or either for typically for an extension, the good practice is to wait until they get an approval and then travel out of the country. So that way they don't have any surprises. On the other side, there are other set of people who are filing a H1B for the first time. So those people, they typically do a change of status filing. They are probably on F1 student visa. They're probably on H4 visa, and they're trying to convert to H1B. So they are doing a change of status from one status to another status. So anybody that does a change of status filing, their employer is doing a change of status filing from one status to another status. So those beneficiaries, they are not supposed to travel out of the country. If at all they travel out of the country after a change of status petition is filed, what happens is the change of status part of the request will be denied. And what that means is the H1B petition could still be approved. So the H1B petition by itself will not be denied, but the change of status part. So there are two things to the H1B. One is the H1B by itself, and then the approval for the change of status. So if somebody travels after filing the H1B petition and they're filing it with a change of status request, their change of status will be denied. What that means is they have to go for a visa stamping. So down the line, they either have to go for visa stamping to get back onto H1B, or if they enter into the country in the future on a different status again, they are required to file another change of status petition. So to avoid this denial of change of status, in general, somebody should not travel if a change of status petition is pending with USCIS.
Yes. Another question, Mr. Chand, if there are any F1 rejections or denials or prior H1B rejections, will it cause any issues when the H1B's filed and is being selected after in the lottery?
So during the lottery, a lot of people got selected, and a lot of people on F1 are filing H1s. Or some people, some. I mean, we have a lot of cases where their filings were done in the past, a long time back, year, 2 years, 3 years back, or so, and they have a denial in the past. So somebody's case was filed in the past, but they had a denial. Or somebody's on F1 visa, student visa, but they had some visa rejections in the past, somewhere at the consulate. So there is a common question from a lot of folks, and they're wondering if any of these rejections from the past, either a H1B rejection or a F1B visa rejection at the consulate, will it impact their current H1B that is being filed in this current fiscal year? If at all there is a H1B denial in the past, one is supposed to disclose that on the I-129 petition. So in general, one is supposed to disclose that they have a H1B filed in the past and that it has been denied. However, in general, if the denial is because of some reason that the employer was not able to satisfy USCIS, they were not able to meet the burden of proof. In general, it should not impact their current petition. So even if they had a denial in the past, typically it will not impact the current petition unless there was some fraud finding in the past. If the previous filing, it had some kind of a fraud finding, it could impact. And again, it depends on what has happened in the past. If it has nothing to do with the employee, so it's because of some issue with the employer in the past, it should not impact the current petition that is being filed. However, if the employee was a part of some fraud, maybe he submitted some fraudulent documentation, some fraudulent educational certificates, fraudulent work experience documents, they could have an issue. But however, if the previous denial is not because of any material misrepresentation or any fraud, the current H1B petition should not have any issue. And same thing with F1 rejection. If somebody had a F1 visa rejection in the past, if it was not because of any fraudulent reason or any material misrepresentation, typically it should not impact their current H1B petition over here, or even with the visa filing in US. Because once the H1B is approved, depending on where somebody is located, if somebody is in India, they would have to go for a visa stamping down the line. So when somebody is going for a visa stamping in India, just because they had a F1 visa rejection in the past, by itself will not cause any issue with their H1B visa.
Yes. And finally, Mr. Chan, can people who are on OPT work even after their OPT is expired, when they are on H1B?
So there is something called a cap gap. So using cap gap, some OPT employees might be able to work even after their OPT expires. And again, this is of two kinds. So some OPT people, they are able to work if it is the initial OPT and they're applying for their STEM OPT extension. If the STEM OPT extension is timely filed, one can work just based on the receipt for the next 180 days. So for somebody who's on OPT, they might be able to work on a receipt if their STEM OPT extension is timely filed. That is one set of people. And we also have the other set where their OPT expired and their STEM OPT, the STEM OPT also expired, but it expired after the H1B was filed. So if the H1B cap petition was timely filed, so it was timely filed after April 1st and before June 30th. That is one important clause. And the other clause is the H1B has to be filed before their OPT expires. So before their work status expires. So in case the H1B petition got filed before their EAD card expired, so it's a timely filing. It's a timely H1B filing. In those cases, people can use something called cap gap. And what cap gap does is they go to their school will issue a new I-20 valid till 9/30/2022, till September 30th, 2022. So using this new I-20, they should be able to work until September 30th, 2022, if their H1B is pending until that date.
Yes. Thank you so much, Mr. Chand, for coming on to our show. We had a wonderful show today. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you.